Subcommittee will come to order. Good morning. Before we get to the subcommittee's first hearing of the 118th Congress, I want to introduce myself. My name is Derek Van Orden. I represent the 3rd Congressional District of the state of Wisconsin. I'm a proud retired Navy SEAL, served our country for 26 years. I did 5 combat tours during that time. I'm a 100% service-connected disabled veteran. I get all my health care through the VA, and I've utilized a lot of the programs myself and with my family and my shipmates that we cover under this purview. I'm also incredibly excited to be working with Ranking Member Levin and other members of the subcommittee to serve those who have served us and given us our freedom. During this last Congress, Representative Levin and Representative Moore did amazing work by enacting meaningful legislation and conducting oversight over the VA. And under your leadership, this committee was not bipartisan. It was nonpartisan. And I think that's the highest compliment you can give anybody in this town. And I intend to follow your example. And I expect every member of this committee to do the same because the issues we're dealing with here supersede politics. I hope to continue to work with my ranking member in this Congress, especially on the Transition Assistance Program, the programs for homeless veterans, and improving the GI Bill. I recognize myself for an opening statement. I'm pleased to be here today to discuss the Uniformed Services Employment and Reemployment Rights Act of 1994, or USERA, and the impact it's had on our service members and veterans. While I am thankful for the Department of Veterans Affairs Employment Training Services program to be here today, I'd like to say that I'm not extremely disappointed that the Department of Defense declined to participate in this important hearing on a program affecting those who serve our country. I am angry at them. DoD's employer support of the Guard and Reserve program has a vital role in protecting service members and educating employees about USERA rights and making sure our men and women transition from uniform to veteran. As more National Guard and Reserve units are called upon active duty, I hope in the future the Department of Defense makes protecting these service members and their jobs while they're on active duty a priority, especially when the department continues to experience a recruiting shortage. At a minimum, I expect them to show up. USERA, which was signed into law in 1994, does an incredibly important job of making sure that when service member returns to civilian life, they have employee protections and are not negatively impacted for protecting our country. This is not a workforce development or maintenance issue. This is a national security issue, as our National Guard and reservists are integral to maintaining our freedoms. When I was a SEAL platoon chief in Iraq, I had 50 Pennsylvania National Guard OPCON to my unit. They were incredibly professional, and one of them was a welder. And I hope that when he finished serving our country, that he had his job waiting for him back in Pennsylvania. And it's incredibly important that we ensure that happens. My goal for today is to hear you, sir, the Department of Labor vets, about their effort to implement a law and hear what we can do to help make the jobs easier, or their jobs easier, your job easier, to carry out the goal of the law. American businesses have been, and I know will continue to be, supportive of the mission of the National Guard, but there needs to be a balance of this mission and its impact on businesses' ability to survive. This is especially true after the COVID lockdowns and the rising inflation created by some poor economic choices of the Biden administration. And I'm also looking forward to listening to the comments from our second panel on how USERA can be improved and what they are hearing about implementing this law from a practitioner's point of view. To be clear, the law is the law, and I will not stand for those companies or government entities who wave the flag and post patriotic videos on Veterans Day and Memorial Day, but then fail to support our service members and their families when they're deployed. Not on my watch. Thank you all for being here today. Look forward to hearing your comments and recommendations. With that, I yield to Ranking Member Levin for your opening statement, sir.
Thank you. Well, first, I want to congratulate you, Mr. Chairman, on being selected to chair this subcommittee. I'm very grateful that in our interactions, you have demonstrated a tremendous commitment to the work that we do on this subcommittee. As you said, it's not partisan in any way. And I want to make sure that we carry forward with the legacy that we've had these last 4 years. First with Ranking Member Bill Arakis, good friend from Florida, and then, of course, with Ranking Member Moore from Alabama. And I hope to follow in their footsteps as Ranking Member to do the work of this committee in a nonpartisan, bipartisan way. I also want to commend the staff. The HVAC staff also works collaboratively, and we very much appreciate that, both majority staff, minority staff. We look forward to that continued collaboration. We accomplished a lot in the 4 years that I was able to chair the subcommittee. We improved education standards. We increased access to the home loan benefit. We housed more homeless veterans. And again, none of that possible without that hard work on both sides of the aisle. And I look forward to visiting Western Wisconsin. I welcome you to San Diego. Hopefully we'll catch it during a really good, beautiful, well, every time of year is a beautiful time of year in San Diego.
I officially accept that invitation.
Excellent. All right, we have it on the record. And that brings us to the work that continues. We've got a tremendous amount more to do, and the subject today, I think, is certainly an example of that. The Uniformed Services Employment and Reemployment Rights Act, or USERRA, is one of the bedrock laws which ensure that service members aren't punished professionally for their commitments to our nation's defense. Building upon the Veterans Reemployment Rights Act, Congress passed USERRA to ensure that no service member loses their job or is discriminated against when they answer the call of duty. Under USERRA, the Department of Labor investigates around 1,000 violations each year, and fortunately resolves the vast majority without needing to refer the case to the Department of Justice. However, this law is not comprehensive for many service members and for their families. It doesn't cover military spouses, nor in my view does it adequately allow for covered service time commensurate with the length of a service member's employment. Also, many service members are forced into arbitration clauses in their employment contracts, giving our service members a Sophie's choice between a paycheck and the USERRA rights. That's why our committee is actively working on legislation to cover military spouses and their families, and finally end forced arbitration clauses. It's no secret that our services are not meeting their recruitment goals. For example, the Army National Guard only managed 66% of their goal the last fiscal year. Making it easier to serve while still pursuing a civilian life will bring more individuals to the service where we can continue to offer the excellent benefits this committee oversees, such as the GI Bill, Home Loan Program, and more. I hope these are all places where our committee can continue to work in a collaborative fashion. Look forward to hearing from our witnesses. Good to see you again. To learn more about gaps in the law, gaps also in the enforcement of the law, and how we can address those gaps. So with that, I'll yield my time back to the chairman.
Thank you, Ranking Member Levin. I'll now introduce our witness panel. Our first witness is from the Department of Labor, Mr. James Rodriguez, a veteran of the United States Marine Corps and Assistant Secretary of Veterans Employment and Training Service. Sir, I'm going to ask the Department of Labor witness on our panel to stand and raise your right hand, please. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect that the witness has answered in the affirmative. Mr. Rodriguez, you are now recognized for 5 minutes to deliver your opening statement.
Good morning, Chairman Van Orden, Ranking Member Levin, and distinguished members of the subcommittee. My name is James Rodriguez, and I serve as the Assistant Secretary for the U.S. Department of Labor Veterans Employment and Training Service, commonly known as USERRA. Thank you again for the opportunity to join you all today. DOL Vets, with the support of our interagency partners, proudly administers, interprets, and enforces the Uniformed Services Employment and Reemployment Rights Act of 1994, better known as USERRA. As described in my written testimony, I first want to highlight my overall theme for this hearing, which is USERRA is critical to U.S. national security interests because USERRA supports the recruitment, retention, and readiness of the all-volunteer force. Based on the national importance of USERRA, we welcome the opportunity to work with Congress, veteran service organizations, and others to continuously improve USERRA. I also want to recognize 3 of our interagency partners that assist vets in administering USERRA: the Department of Defense's Employer Support of the Guard Reserve, the U.S. Department of Justice, and the U.S. Office of Special Counsel. For the remainder of my oral testimony, I will highlight 3 important messages that support the overall theme of this testimony. First, VETS delivers positive USERA outcomes for employees and employers alike. VETS conducts robust public outreach to educate service members, employers, and others on the USERA rights and responsibilities. Since the terror attacks of September 11, 2001, which resulted in the single greatest mobilization of reserve components, VETS has briefed more than 1 million individuals on USERA. So far this fiscal year, VETS has already conducted over 500 compliance assistance events nationwide, informing employees and employers alike of their rights and responsibilities under USERA. When VETS is unable to resolve a USERA issue through compliance assistance, a service member or veteran can submit a claim to VETS for investigation. When this occurs, VETS assigns the case to a trained USERA investigator. And on average, over the past 3 years, VETS has closed 943 cases for investigations per year. When VETS investigators find a violation of USERA, they work diligently with both the claimant and the employer to resolve the case to their mutual satisfaction. Of cases in which VETS found a violation of USERA in FY 2021, VETS resolved 85% of those cases. VETS has also converted its 6 regional senior investigators to 1800 series, or full-time investigators, and hired an additional 10 full-time 1800 series investigators to serve among the 6 national regions. Second, VETS identified gaps in service delivery and coverage that Congress may want to address. Military spouses are not presently covered under USERA. Removing barriers to military spouse employment could minimize some of the disadvantages and disruptions that Congress sought to address in enacting USERA. It could also alleviate a significant stressor on military families while recognizing the vital role of military spouses in the retention, recruitment, and readiness of the all-volunteer force. Employment protections could easily help military spouses build successful careers without frequent interruption and restarts. They could bolster the financial stability of their families, especially during their service members' transition from military service to civilian life. Third, VETS asked for future congressional support to provide full funding of the VETS Federal Administration appropriation. VETS USERA program does not have an independent budget. It is funded exclusively through the VETS Federal Administration appropriation. In FY 2022, the President's budget request for the VETS Federal Administration was $52.5 million, but Congress only appropriated $46 million. In FY 2023, the President's budget request for the VETS Federal Administration was just over $53.7 million, but Congress only appropriated $47 million. Appropriations below the budget request have negatively impacted VETS efforts to digitally modernize our paperless VETS case management system, otherwise known as VCMS. That would enhance the customer service experience of our veterans, service members, their families, and their employers. In closing, VETS looks forward to working with the subcommittee to ensure that USERA remains of fundamental importance to the recruitment, retention, and readiness of the all-volunteer force. VETS is also committed to continued collaboration with our interagency partners to provide positive USERA outcomes to employees and employers alike. Chairman Van Orden, Ranking Member Levin, distinguished members of the subcommittee, thank you for the opportunity to highlight important work VETS is doing in support of our veterans, service members, military spouses, and who have served our country, and I look forward to any questions you may have.
Thank you, Mr. Rodriguez. The written statement of Mr. Rodriguez will be entered into the hearing record. We'll now proceed with questionings, and I recognize myself for 5 minutes. Mr. Rodriguez, in your testimony, you said that in 2021, DOL VETS resolved 85% of the claims to the satisfaction of the claimant. This means there's 15% that were not resolved to their satisfaction. Were those all referred to the DOL or the OSC, the Office of Special Counsel, those 15%?
Well, Mr. Chairman, what we do, once we finish our part of the investigation, working with the claimant, then we give them the option to have that claim referred to DOJ, but it's entirely up to the claimant. And once the claimant decides to do that, then we do refer it to DOJ. We have a good track record within DOJ that if a claimant does get referred to there, that they have a good track record of resolving that claim. However, if it's not to their satisfaction, then the claimant can also take it to civilian court if they decide to do so.
So of the 15% that is not resolved to the satisfaction of the claimant, do you have an idea? I'm just trying to get a grasp of how many people we're talking about here.
So I don't have the exact number in front of me, sir, but I'd be glad to provide that in a response, written testimony response back to you.
That would be
I
awesome.
don't have the exact number at this time.
I appreciate it greatly. And then they have to pay, if they decide to go to a civilian court, that is paid out of pocket by the service member, is that correct?
That's correct.
Okay, writing that one down. I also just want to acknowledge the fact that we talked about this briefly, that it is very clear that military spouses are the most overeducated and underemployed demographic, and we're going to try to work that out. There's several different groups that work with military spouses, but you're absolutely correct. That transition period when you're twice the husband and half the paycheck, it'd be fantastic to have the spouse being able to pick up that slack. So thank you very much, sir. I'm going to yield back my time so that my colleagues can have time to speak. I now recognize Mr. Levin.
Thank you, Mr. Chairman. Assistant Secretary Rodriguez, good to see you again. Thanks for being here today. I know we're here to talk about USERRA. I'll ask about that shortly, but while you're here, I want to ask you a few questions about another law that DOL Vets is responsible for enforcing, and that's the Vietnam-era Veterans Readjustment Assistance Act of 1974, also known as VEVRA. Last year, my staff inquired with DOL about Vets' fiscal year 2021 report to Congress, which omitted VEVRA data as required by statute. I appreciate that DOL at that time committed to provide the available data in future reports, but I want to make sure this doesn't happen again. Why was the data excluded from the fiscal year 21 report, and what specific steps is DOL taking to ensure it'll be included in the future?
Well, Ranking Member Levin, I take full responsibility for that not being submitted. What I will tell you that we've been working with our colleagues at the Office of Federal Contractor Compliance, who has the ability to capture this data, which we're working with them to try to find the right data from the state levels, but also looking at what data is the most relevant to the report requests. And so we're still in the process of doing that, and I can assure you that we will work through this to provide the report to you.
Thank you. We appreciate you following up, appreciate your taking full responsibility. And one thing DOL did mention is that it may not have the mechanisms to track or collect the number of qualified covered veterans receiving priority and employment referrals, but I will mention that DOL committed to making sure they figure out a path forward to track and report this information. So have you taken any specific steps since we brought this up with your office?
We have. We've been working with the Office of Federal Contractor Compliance, looking at what data they currently have and what data they do not have. And so our teams have been working with their teams to figure out, again, what information is the most relevant. But we've had numerous conversations with them at various levels of our organization. We plan to continue that to figure out how we can, again, conceptualize the right report, and we're still in the process of working on it.
Okay. We appreciate your following up, and it's an important priority as we've got constituents specifically who are impacted by the lack of this data being included as per required by statute, so we appreciate it. I'll turn to USERRA, and actually I'll hold for now. I will wait until our next witness. I'll yield back.
Thank you very much. I now recognize Mr. Siscomani from Arizona for 5 minutes.
Thank you, Chairman. And I look forward to working with you and the continued leadership of this subcommittee. I want to thank all the witnesses for coming here to testify on this important topic, and I'm proud to represent Arizona's 6th Congressional District with over 70,000 veterans that call my district home. My district has the 9th highest concentration of veterans for any congressional district in the U.S. So I know intimately that the work that we do here must be focused on advancing bipartisan solutions for those who fought to protect our country. Mr. Rodriguez, thank you for being here. Thank you for joining us, and thank you as well for your service. In your testimony, you speak about the need to break down the barriers to military spouse employment by including USERRA for military spouses. How many spouses do you have an idea would be included in this new rule?
Congressman, based off the data that we currently have, working with our DoD partners, capturing data from things that they've also looked at as far as research, almost a million, right under 1 million military spouses would be affected by a change in USERRA.
Thank you. Do you have an estimate of how many more USERRA cases and Department of Labor vets would see if military spouses were included in USERRA?
How many more cases we would see? We're still working through that number. What we do know, though, is that in our current situation with the amount of investigators we have, we'd have to update the amount of investigators, hire new investigators to help with those claims. We're still going through the estimates right now, but we don't have an exact number of how many more cases we would have.
Would the same be true for the cost of this, the final price tag that you think would impose on this new rule? So if you extend the benefit to spouses, any estimate on the cost that the private sector would have for implementing such a change?
We do not have an estimate on the cost at this time.
Okay. Do you think spouse USERRA claims would be more difficult to verify and adjudicate with this change?
I think based off of our track record with USERRA claims processing, I mean, as a chairman and it's been mentioned in our written testimony, 87% of our cases are roughly adjudicated. So I have full confidence that we'd be able to resolve the same amount of cases if we had military spouses as part of the USERRA process.
Okay, and then going back to the other two questions that you don't have all the details on this, is this something that you could get in terms of the cost and also the cost of the private sector? Just obviously that would be an estimated cost of that, and the estimated on the Department of Labor vets would see on the caseload increase there as well, just to get an idea of what would be coming.
So we'd be glad to do that, Congressman. We'd be glad to submit that information back to you post-hearing.
Thank you, Mr. Rodriguez. I yield back my time, Mr. Chair.
Thank you, Mr. Siscomani. I now recognize Mr. Mervan from Indiana for 5 minutes.
Thank you, Chairman. At this time, I'd just like to ask a question about USERRA. When you speak to employers about USERRA, what do they say, and why do you think some employers have USERRA violations?
Congressman, I speak to employers all the time, and I can tell you for the most part, almost every employer wants to hire veterans, Guard, Reserve, because they know how valuable they are to their bottom line. They know it's good for business. They know the value that veterans bring to their industries. So for the most part, every organization wants to hire veterans, and they can't hire enough veterans for that part.
What is the motivation for the violations, do you think?
I think most of it is a lack of education. I think when you look at the lack of education with regards to how to employ someone who is a Guard or Reserve, and they are in the process of getting orders, maybe the first time, and the organization may not have ever had someone that was Guard or Reserve that worked for them. So what we try to do is mitigate that by providing outreach, providing education to employers who ask of us, by being proactive in providing that outreach. Our investigators are constantly, when they're not investigating, they're constantly providing training and education to organizations.
So one of my questions, new to the committee, a National Guardman is deployed, comes back, there's a disruption in employment. How do they prove discrimination?
Well, if they feel like they're discriminated, they can file a claim with us directly and let our investigators do the work. So the investigators will work with the claimant and the employer to try to come to a resolution. So if they feel like they've been discriminated, they have every right to file a claim.
And then one of my follow-up questions, for military spouses, as the chairman talked about, the DOL vets considers other statutes that may improve the has the DOL considered other statutes that may improve the employment situation for military spouses rather than USERRA?
So we looked at other statutes. We've done a lot of research. We still feel that USERRA is the best avenue for that.
Okay. With that, I yield back. Thank you, and thank you for your service and your wife's service.
Thank you, sir.
Thank you, Mr. Mervan. I now recognize Mr. Crane from Arizona for 5 minutes.
Thank you, Mr. Chairman. Man, I never thought I'd say that. Holy cow, this town is in trouble. All right.
Nothing like a friend.
If you guys only knew this guy, I mean, you'd be concerned as I am. Thank you guys for showing up today. I'm also from Arizona, like my colleague, Mr. Siscomani here. I represent the rural district. A lot of patriots, a lot of veterans up there. And I also formerly owned a veteran-owned business where we hired a lot of veterans. It was called Bottle Breacher. Have you ever heard of it, Mr. Rodriguez?
I've heard of it now because I looked it up.
Okay. It's kind of disappointing, Mr. Rodriguez, I got to tell you. I'm disappointed that you never had a bottle breacher, because I know some vets out there most certainly did. A couple questions I have for you real quick, sir. In your experience, what type of entity is most likely to have USERRA claim brought to DOL vets? Small or large business, private, public, or nonprofit?
So Congressman, I can tell you it varies. So I think every category that you mentioned are likely to have a USERRA claim against them, just because, again, as I mentioned earlier, it could be a lack of information about the USERRA process, a lack of information about the service members' rights. And so it could be either one of those, could be federal government, could be state government. So every one of those entities that you listed could fall into that category.
I recognize that, Mr. Rodriguez, but have you seen any trends?
Trends, we have trends. I don't have that data in front of me. I'd be glad to provide the trends to you, but I don't have that data in front of me. But we do, again, when you look at industries, they vary. Our veterans are employed in every single industry, as you know. And so I don't have those exact trends in front of me, but I'd be glad to provide those to you.
Thank you, sir. Next question. Some veteran service organizations in our second panel are concerned that DOL vets investigators are not consistently conducting such oversight as is required by the USERRA Operations Manual. They have also stated that DOL vets has wrongly investigated claims. Why has DOL vets refused to send this manual to anyone?
Well, Congressman, I can tell you our manual has been updated, and based off of policies, we're sticking to the policies that are currently in place. And so if the policies dictate that we do not release the manual right now, we're going to stick to the policies. But I can give you some areas of improvement that we've had where often folks do not realize that the areas that we've improved when it comes to investigations, if I may. One of those things we've created specialized full-time investigator, 1800 series, as I mentioned, positions in our 6 regions exclusively in investigations. We've updated our investigators manual. Also, to emphasize the importance of conducting witness interviews, as well as the use of subpoena power to obtain evidence. We've also implemented a report of investigation for each case as a tool for investigators to plan their investigation and conduct case analysis, for supervisors to conduct frequent and meaningful reviews throughout the course of investigation. And we've continuously looked at ways to improve our investigator training. And so we are definitely taking a proactive approach to ensuring that our investigators are well-trained and well-positioned to support our service members when they file a claim.
So just a real quick follow-up there, real quick. Why again has DOL vets refused to send this manual out? What's the purpose of keeping it in-house?
So at this point, I can tell you right now that I'll have to review that. I know that's been a practice of ours. I'll definitely review the practice and figure out if we can release it. But in our current practice right now, we're not releasing it.
Can you please get back to us on that, Mr. Rodriguez?
I definitely will.
I yield back my time, Mr. Chairman.
Thank you, Mr. Crane. I appreciate that greatly. Mr. Rodriguez, I'd like you to take a note on that. I'd like this committee to have access to that manual. I think it's incredibly important that we have transparency amongst your position and mine. Good to go.
I agree, Mr. Chairman.
All right, let's get her done. At this point, I'd like to recognize Mr. McGarvey from Kentucky for 5 minutes, sir.
Thank you, Mr. Chairman. Appreciate it. Thank you so much. Thank you for your testimony. Thank you for being here and highlighting the importance of USERRA. I'm glad to know that our service members and vets back home in Louisville, Kentucky have some legal protection, both when active and when they return. Always been looking out for workers and employees. I'm proud to advocate for the protection of USERRA. And in my opinion, no employer should have the ability to discriminate against any workers, whether on the basis of being a veteran, race, gender, you name it. We know that USERRA offers some level of recourse for veterans, but like so many things, we need to make sure that these protections are enforced with deliberate speed and that they don't just exist on paper. So, Mr. Rodriguez, what do you think Congress should do to improve the enforcement of USERRA?
Well, Congressman, that's a great question, as I wholeheartedly believe that there are ways to improve USERRA. And I know the committee's worked on this in the past, and what we want to do is continue to work with the committee to find ways to improve it. But if I can, I would like to highlight a couple of ways that we can work with the committees to improve USERRA. Is one, eliminate mandatory arbitration agreements. I think we've all agreed that that is something that is a disadvantage to our service members. 2, permitting pattern or practice claims. 3, voting or avoiding state sovereign immunity defenses, and then authorizing late payment penalties. One of the biggest challenges we have is when a resolution is agreed upon between the claimant and the employer, then one of the challenges we have is ensuring that that individual does receive their compensation in a timely manner. So we want to ensure that if there's a way to create penalties, if you will, for someone who does not meet that obligation, then we'd be more than happy to work with the committee on that. Allowing DOJ representation for all plaintiffs, as well as including DOJ pattern or practice authority, and then adding DOJ civil investigative demand authority. Those are ways that we've looked at in depth that we figure can definitely help improve the USERRA process.
I really appreciate you sharing that. I think those are good steps that we can take to help protect our veterans, help protect our service members. My brother right now is in his 20th year of active duty and likely to get deployed again soon. I know in talking to him and to so many other active duty service members, one of the things that they are concerned about when preparing for active duty is, of course, leaving families behind. And this applies when we talk about USERRA, looking at it with spouses. If Congress expanded USERRA to cover military spouses, would you all have the capacity to enforce it?
So one of the things when we look at the ability to expand USERRA to spouses, we know that is something that's well-founded, well-needed. It's something that many organizations have talked about in the past, and we're having even more robust conversations about that now. But when we talk about it, the capacity of it, from a budget standpoint, unfortunately, I cannot speak about the budget at this point because it hasn't been released. But we definitely would want to work with Congress to look at the ability to have more capacity, if you will, to protect military spouses.
Thank you. I think that's something we'd love to talk with you about and work with you on as well, is strengthening USERRA to protect our active duty and our vets, and also that expansion to spouses. As we know, whether it's service here, whether it's service in the military, you don't serve alone. And making sure that military spouses are protected, I think, is important as well. Thank you for your testimony. I yield back.
Thank you, Mr. McGarvey. I now recognize Ms. Ramirez from Illinois for 5 minutes.
Good morning. Thank you, Chairman Van Orden and Ranking Member Levin, for taking the time to consider this real critical issue, enacting to protect military service members, veterans, and their families from employment discrimination due to their service. I represent Illinois' 3rd Congressional District, and it's a district that starts in the northwest side of the city of Chicago, and it goes to Elgin in West Chicago in the suburbs. There are many critical infrastructure improvements needed there that will benefit greatly from Infrastructure Investment and Jobs Act. But we need to build and support an empowered workforce with livable wages to actually carry out the work. And we know we have a long way to go to do that. Employers should know that Uniform Service Employment and Reemployment Rights Act requires them to treat employees who take leave from uniformed service duty respectfully and without discrimination. And this includes veterans with all rights and benefits that they would have earned in their civilian employment had it not been interrupted. Additionally, employers must protect on employees' job seniority when performing uniformed service duties. Employers must understand their obligations under this law to properly support the uniformed service personnel to ensure compliance with the USERRA requirements. Doing so will protect both employees serving in uniformed services as well as the integrity of the entire organization. So with that said, Mr. Rodriguez, I want to talk a little bit about hourly versus salaried employees. Does the Uniform Service Employment and Reemployment Rights Act, USERRA, allow employees to continue to accrue vacation time during their military service?
Yes, it does, Congresswoman.
Great. What about for hourly employees? Do they accrue vacation time as well?
Yes, if they are afforded vacation time as part of their roles and responsibilities, then that is protected by USERRA.
Great. How are hourly employees treated differently from salaried employees under the law?
They're not treated any differently than any of the other employees.
Okay. And now in terms of health insurance, can you explain how health insurance coverage is or isn't protected for hourly employees?
So under the current USERRA law, if they have health insurance coverage, then it's protected. All their rights, all of their benefits are protected under USERRA.
So I want to That's really important to hear, and I think it's important as we talk about how we provide the protections and the benefits that our veterans deserve, and certainly those that are going back to active duty. I want to talk a little bit also about arbitration. What is the difference between substantive and procedural rights that may be affected by mandatory arbitration clauses?
So the legal definition is pretty complicated, as you can imagine, and I definitely can make sure that you have that legal definition. So I don't want to not convey that accurately, but what I can tell you, when we look at mandatory arbitration, depending on what courts are look at it from the substances and the other piece of it, they can decipher it differently. And so one of the things that we want to ensure that veterans are not forced to have arbitration as a supplement over USERRA. We want to ensure that their rights are protected through USERRA, and that's one of the things that we would look forward to working with the committee to ensure that we find ways to protect those rights and veterans are not forced into arbitration prior to having the ability to file a USERRA claim.
Thank you, Mr. Rodriguez. So I just want to thank you for your attention to this critical matter. As you can tell here in our subcommittee, we really look forward to discussing how we can further educate public and private employers on USERRA so that the uniformed services personnel serving our country receive legal entitlements without discrimination or reprisal. I know that together we can ensure that service members and veterans are protected from employment discrimination due to their uniformed service duties. So thank you, and I yield back.
Thank you, Ms. Ramirez. Thank you, Mr. Rodriguez. You're excused. I hope that you and your staff will stay for the second panel, and I'm just going to tell you, Semper Fi, Devil Dog. Keep it on.
Thank you, Mr. Chairman, Ranking Member Levin, and members of the subcommittee. It's been a pleasure, and Semper Fi.
All right. Okay, we're going to go ahead and get set up for the second panel. We'll take a 5-minute break. Committee will come to order. In our second panel, we have several veteran service organizations. Colonel Patton from the Reserve Organization of America, Mr. Mike Hadley, Director of Legislative Affairs at the National Guard Association of the United States, Mr. Kevin Hollinger, the Legislative Director of Enlisted Association of the National Guard of the United States, and Mr. Jonathan Taylor, Principal at Gupta Wessler. I would now like to welcome the witnesses on our second panel to the witness table. You're here, and ask you to please stand and raise your right hands. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Very well, thank you. Let the record reflect that the witnesses have answered in the affirmative. Colonel Patton, you are now recognized for 5 minutes to deliver your opening statement.
Good morning, Chairman Van Orden, Ranking Member Levin, and distinguished members of the House Veterans Affairs Economic Opportunity Subcommittee. On behalf of the Congressionally Chartered Reserve Organization of America, thank you for the opportunity to participate in this important oversight hearing on protecting the employment and reemployment rights of our nation's service members and veterans. The Reserve Organization of America, or ROA, commends the subcommittee's commitment to fortifying the integrity of USERRA to ensure that service members are not disadvantaged in their civilian careers because of their military service, that they are promptly reemployed in their civilian jobs upon return from duty, and that they are not discriminated against by employers because of past, present, or future military service. In this spirit, ROA offers the following insights into how to better gauge the effectiveness of existing USERRA protections, modernize regulations governing USERRA enforcement, and ensure DOL vets personnel are properly resourced and trained. First, ROA urges the members of this subcommittee to support amending Section 4332 of USERRA to require the Secretary of Labor to fulfill additional reporting requirements, including reporting the number of closed case reviews conducted by the agency and the number of disposed cases found to have been originally closed by DOL vets with substantive errors. Current law requires the Department of Labor to report each year on the number of USERRA complaints received, the number of cases substantiated, and the number of cases referred to the Department of Justice or to the Office of Special Counsel. However, this data is merely transactional, and while it may serve to demonstrate the task load of USERRA complaints filed by DOL vets for budgetary purposes, it does not provide any indicators as to the accuracy or the completeness of how the complaints were processed. I served in the United States Air Force for 31 years. One of the most valuable lessons I learned, first early on as an officer, then as an operational unit commander, and then as well as a leader of large headquarters staff organizations, is that you get what you inspect and you get what you measure. And so without a proper inspection of DOL vets' performance to effectively execute the various provisions currently in USERRA law, we do not get a proper measure of USERRA. To correct this, ROA urges the members of the subcommittee to support directing a GAO study to examine DOL vets' performance of its statutory responsibilities under USERRA. I might suggest that the scope of that would include the findings of past GAO reports and past Department of Labor Inspector General reports, and the evaluation of the previously assured corrective actions by DOL vets to each of those reports. The desired end state of this study is to measure the capability and the preparedness of DOL vets to ensure service members and veterans are truly protected under USERRA, identify potential changes in ensuring compliance with USERRA, and provide recommendations that would improve USERRA enforcement. While these studies may take time to develop and unfold, an action that can be taken now is to update the Department of Labor's regulations under 20 CFR that it promulgates that drive how USERRA is implemented. DOL's regulations currently serve as the primary basis for training and providing references to the investigators charged with preserving USERRA rights and benefits of service to members and veterans. However, these regulations in 20 CFR were last promulgated in 2005, and there have been several amendments to USERRA since then. The regulations are 13 years out of date to the most recent amendments to USERRA that were enacted. ROA believes DOL should be compelled by Congress to update their regulations on a more regular basis to ensure that investigators and staff are equipped with what is required to completely fulfill their statutory responsibilities under USERRA. Further, ROA encourages the members of this subcommittee to take a proactive approach in pulling back the curtain on how DOL currently enforces USERRA and has enforced USERRA in the past. Under federal FOIL law, each agency of the federal government shall make available to the public, and I quote, administrative staff manuals and instructions to staff that affect the member of the public. Despite this, DOL has invoked an exemption to avoid the release of its own USERRA operations manual based on the assertion that the manual is compiled for, quote, law enforcement purposes, and that its release would, quote, disclose guidelines for law enforcement investigations or prosecutions that, if disclosed, could reasonably be expected to risk circumvention of the law. There's nothing known to ROA to be within that manual that could remotely or much less reasonably be construed to provide an advantage to any party trying to circumvent a USERRA regulation or the law. ROA believes that it is wholeheartedly necessary to immediately make the manual in its entirety public for the purposes of ensuring its processes and procedures are truly aligned with the text and the intent of USERRA. On behalf of ROA, thank you for your support of our young men and women in the reserve components, your support for their employers, and for our nation's veterans. And thank you for providing ROA with this opportunity to testify before you today. I look forward to any questions you might have.
Thank you, Colonel Patton. I now recognize Mr. Hadley for 5 minutes to deliver your opening statement.
Chairman Van Orden, Ranking Member Levin, and other distinguished members of the committee, on behalf of almost 445,000 members of the National Guard Association of the United States and nearly 450,000 members of the National Guard, we truly appreciate the opportunity to share our thoughts on today's topic for the hearing. We thank you for your oversight and the attention paid to the issues affecting those that have served and are currently serving our nation. The operational tempo of the National Guard has increased significantly over the past 20 years, and even more so recently. From overseas deployments in support of combatant commands, the pandemic, civil unrest, wildfires, and floods, the National Guard has remained always ready. In 2021 alone, the National Guard executed over 10 million man days. This has put an immense strain on our service members, families, and employers. National Guard soldiers and airmen are unique in that they simultaneously manage civilian careers alongside their military careers. This has become even more challenging as military requirements expand. Regardless of what the law says, we know that Guard members' ability to find and maintain steady employment has been impacted and challenged. USERRA is in place to protect against discriminations of our soldiers and airmen. Employers must be educated regarding existing law and USERRA protections and should be expanded where the gaps exist. The 116th Congress made great progress in the Veterans Health Care Benefits Improvement Act, which ensured coverage for specific areas of state active duty. However, those protections only covered duty beyond 14 days. State National Guard response missions are often less than those 2-week time period. We ask that the committee remove this limit to protect all state active duty regardless of the length. Another area of concern is the time off for treatment of service-connected disabilities. Military duty can be physically strenuous and injuries can occur. As members return from their missions, they should be given the time for appointments, rehabilitation, physical therapy, whether the Department of Veterans Affairs or other private health care facilities. The service members should focus on improving their health care without concern for retribution from their employer. That said, a healthy soldier airman is one that has health care coverage. Today, there are currently over 60,000 National Guard members that do not have health care of any sort. This is a key readiness issue. It is imperative that all service members have access to health care needed to meet their medical deployment requirements. We ask all members to support the Health Care for Our Troops Act. Affording zero-care healthcare or TRICARE coverage will dramatically increase readiness, solve turbulence in moving on and off health care plans, and ultimately save money. It will also provide additional cost savings benefit to the employer who would not need to provide health care to this employee. We understand that the challenge the military service can place on employers. An additional way to encourage our employers is through the Reserve Employers Comprehensive Relief and Uniform Incentives Act. The Recruit Act would authorize an annual tax credit for small business employers who employ National Guard and Reserve members and would go a long way in supporting communities. NAGA supports and encourages the reintroduction of this bill in the 118th Congress. I thank you again for inviting NAGA here to testify today. Your efforts are critical to the well-being of our service members and the success of our National Guard. I look forward to continuing our work together and sincerely appreciate the steadfast leadership from the members and their staffs in advocating for the men and women of the National Guard. Thank you.
Thank you, Mr. Hadley. The written statement of Mr. Hadley will be entered into the hearing record, as will Colonel Patton's. Mr. Hollinger, you're now recognized for 5 minutes to deliver your opening statement.
Chairman Van Orden, Ranking Member Levin, and members of the committee, thank you for the opportunity to be here today and provide our thoughts on USERRA protection. INGUS is the only professional military service organization dedicated solely to the enlisted members of the National Guard. Unfortunately, National Guard service members frequently do not receive the same comparable benefits or afforded the same protections as active duty component, and in some cases, even other reserve component service members, due to the duty status under which they are working. Today, INGUS would like to address 3 concerns regarding USERRA protection affecting the National Guard: an employer's ability to use forced arbitration as a means of settling legal issues concerning USERRA, non-covered state-funded service in uniform, non-covered family members. Removing forced arbitration is important legislation that will empower service members and their families against the practice of forced arbitration. This much too standard dispute process strips our service members of their rights under the Service Member Civil Relief Act, SCRA, and USERRA. Forced arbitration is a one-sided, non-transparent process in which service members have very little chance to achieve a favorable outcome when their rights and protections set forth under these federal laws are violated. Service members need this legal protection restored without delay, not another study to show what they already know, that forced arbitration hurts them and their families and renders rights granted by SCRA and USERRA virtually meaningless. INGUS urges the 118th Congress to introduce and pass legislation removing forced arbitration from USERRA and SCRA. The next concern I would like to discuss is non-covered state-funded service in uniform. State active duty is available for governors and adjutant generals to use for various state concerns like state environmental disasters, civil unrest, or fulfill community needs. If a service member do not fall under one of the following 3 categories, they will not be protected by USERRA: state active duty for 14 or more days, state active duty in support of the national emergency, state active duty in support of a major disaster declared by the President. Since March of 2020, the National Guard has activated over 320,000 service members in support of many overseas and domestic activities. From combat missions in places like Afghanistan to running COVID tests and vaccine sites in the U.S., our dedicated service members of the National Guard must know that their job is safe and available when they return. In Torres versus the Texas Department of Public Safety, the Supreme Court considered whether the state, by ratifying the Constitution, gave Congress the power to authorize suits against states using its constitutional war powers. In the opinion authored by Stephen Justice Breyer, he stated, Congress's ability to build and maintain the armed forces fits the test outline in Penny's test. Thus, in joining together to form a union, the state agrees to sacrifice their sovereign immunity for the good of the common defense. With that opinion, we now know all duty statuses performed by National Guard should be considered by Congress. Therein, INGUS would urge the 118th Congress to ensure USERRA protections for all Reserve and National Guard duties without timelines and regardless of who orders them to duty. The third concern I would like to discuss, USERRA protection for spouses. Everyone knows the sacrifice of the Reserve and National Guard personnel. being pulled from their everyday lives and thrust into service of our country. But imagine if you were removed from your spouse at a moment's notice, and if you still have or have had small children, how hard would it be for your spouse to wake or make up for your absence? Well, that's how being a National Guard spouse works. Spouses often must take time away from their employment to figure out new schedules. At a moment's notice, they become the sole head of household. Army General Raymond Ordinero often said, "Our country is great because of our military is great because of our service members, and our service members are great because of our families." I think putting these three things together is the correct answer. Angus would urge the 118th Congress to legislate USERRA's protection for spouses of activated reserve and Guard service members. Finally, I would like to say military and veteran law and policies are often developed without understanding or appreciation for the essential distinction between the National Guard and active duty service. The members of the National Guard regularly lose out, and so do their families. These past 3 years have shown America how important the National Guard is to everyday life. Regardless of the mission, a pandemic assistance, civil unrest, capitol security, or overseas direct combat assistance, the National Guard has selflessly answered that call. Despite many of these activations happening at a moment's notice, the National Guard did not hesitate. They faithfully served their country and communities and accomplished the mission. Thank you for your time, and I look forward to your questions.
Thank you, Mr. Ollinger. The written statement of Mr. Ollinger will be entered into the hearing record. Mr. Taylor, you're now recognized for 5 minutes to deliver your opening statement.
Chairman Van Orden, Ranking Member Levin, and distinguished members of the subcommittee, thank you for inviting me to testify today. I want to make 3 points. First, USERRA has never been more important than it is today. Since September 11th, our country has heavily relied on reservists and National Guard members to defend us. These service members account for nearly half of the 2 million people in our military, and they're essential to our safety. Most days, they go about their lives like anyone else, working their civilian jobs, caring for their families, worried about their finances. But they're also trained soldiers who balance their roles as civilians with ongoing military obligations so they can stand ready to be called to active duty at a moment's notice. USERRA is the key statute that protects these service members in the workplace. It's the reason that when they're called to serve their country, they don't have to worry that their jobs will be there for them when they get back, nor do they have to worry that they'll be disadvantaged or discriminated against simply because they answered the call to serve. Take these protections away and our military would have a hard time convincing people to join the reserves. For that reason, as one Senate report put it, it is imperative that employers comply with USERRA. But employers often fail to do so. And when that happens, Congress has given service members the tools to protect themselves. They can go straight to court. There, they can shine a light on their employer's practices, present their case to a neutral judge and jury, rely on the rule of law, and obtain a written decision that can be appealed and reviewed by the political branches. But none of that will happen if they are forced against their will into secret arbitration, which leads to point 2. USERRA has never been more at risk than it is today. When it was enacted in 1994, forced arbitration was barely a thing. Now it's everywhere. Corporations have learned from their lawyers that they can escape accountability for violating the law by inserting fine print into their take it or leave it contracts. As a result, getting a job increasingly requires checking one's rights at the door. Most non-union private sector employers in the United States, over 60 million American workers, are now subject to forced arbitration. Service members are no exception. Despite strong statutory language to the contrary, including a provision barring enforcement of any contract that impairs USERRA's rights, several courts have held that USERRA permits employers to impose forced arbitration on service members. That violates the statute's text and purpose, but more than that, it is immoral and unwise. A real-life example helps to make the point. In 2012, a reservist named Kevin Ziober was called to active duty in Afghanistan. On his last day of work before his deployment, his employer threw him a party to celebrate his service. But afterward, they summoned him to a room and told him he was being fired. This meant that as Kevin was heading to a war zone, he now had to worry about how to pay his bills when he returned. That's the last thing that should be on a service member's mind as they go to war, and it's exactly why USERRA exists. But after kicking him out of his job, his employer then kicked him out of court, invoking a forced arbitration clause. Service members like Kevin deserve better. Fortunately, as judges have noted, Congress can fix this problem. Now is the time for it to do so and clarify what should already be clear. Forced arbitration has no place in USERRA. Last, this isn't a partisan issue. Over 80% of Republicans, Democrats, and independents support federal legislation to end forced arbitration, and those percentages are surely higher when it comes to our troops. If nothing else, basic fairness dictates as much. The least, our service members fight for our freedom and defend our Constitution. The least we can do is preserve their freedom to decide how to protect themselves and defend their constitutional rights. Forced arbitration is the opposite of these values. As the Bush Department of Defense observed, waiver isn't a matter of choice and take it or leave it contracts of adhesion. And the very reason we have a Bill of Rights in the first place is because the original Constitution lacked a right to a civil jury trial. As John Adams said, representative government and trial by jury are the heart and lungs of liberty. But eliminating forced arbitration for USERRA claims isn't just about fairness to individual service members, it's also about empowering them as a group and protecting us as a nation. Forced arbitration doesn't channel cases into a better system for resolving disputes, it extinguishes them entirely. And for those precious few cases that actually get arbitrated, the secret nature of the proceeding means that even if a service member can beat the odds and win, no one else benefits. No one will become aware of the unlawful practice or the fact that they might have a claim, nor will Congress have any idea about how the statute is being applied and whether it needs to be amended. Add it all up, and the upshot is plain. Forced arbitration badly undermines compliance with USERRA, and it makes us less safe. I'm happy to answer your questions.
Thank you, Mr. Taylor. The written statement of Mr. Taylor will be entered into the record, the hearing record. We will now proceed to questions, and I recognize myself for 5 minutes. You guys may not have noticed it, but in the spirit of our opening statements, you just saw bipartisanship take place. So, Colonel, I spoke to Ranking Member Levin. We're going to get a hold of the GAO, and we're going to make sure that they start a study to report what's going on with the actual, we want the real numbers for this arbitration. So Mr. Rodriguez will be made aware of this. We'll apparently have to send him a letter because he did not. Where are you? Still with us. There you are, devil dog, sneaking in the back up on me, Mr. Rodriguez. We're going to get that to you, and we want real numbers because, as we said, opening up this statement, we really want to help our veterans. And you owe us transparency, and we owe you honesty. How's that sound? Pretty good? All right, good call. Colonel, thank you for your 31 years of service. I appreciate it. As a Navy guy, it's really hard for me to say that, but I mean it. I know you're in the Air Force and still good to go. The committee staff, our staff, has heard that they have concerns since the Biden administration has taken over the DOL, that the DOL vets, the Department of Labor, have been difficult to reach when regarding these issues. And what does DOL vets, what do you need to hear from these folks? And how many times have you tried to talk and bring up these issues with DOL vets? What do you guys need to hear specifically regarding to USERRA?
Thank you for the question, Mr. Chairman. I would say in the preceding 3 years, so that actually spans the first half of the current administration and the trailing end of the previous administration as well, that we've been trying to reach out on a regular basis and reaching out into various levels of the organization, at the action officer level, as you will, at the state level leadership, at the region level leadership, and at the national office. I can get you fairly accurate numbers as to the exact number of engagements of each, but suffice it to say they've been regular, and deliberately we have tried to reach out at different levels within the organization to at least get to consensus on defining the problem, because until we get to consensus on defining the problem, there's not much hope in getting to consensus on getting to the solution.
Roger that. I would really appreciate that data so we have a solid metric that
Thank you, sir.
we can bring you back. One follow-up for you. While DOL Vets administers USERRA, my subcommittee has legislative jurisdiction over this issue. Is your staff willing to discuss the issues with our staff and work towards ensuring your Reserve Officer Association's concerns are listened to and legislated?
Absolutely, Mr. Chairman.
Fantastic. I yield back.
Thank you,
I now recognize Ranking Member Levin for 5 minutes.
Thank you, Chairman, and thanks to all our witnesses for being with us and for your testimony. I have been a strong supporter and am a strong supporter of strengthening benefits and protections for our Guard and Reserve members. It's been a pleasure working with many of you and others that aren't here over the past 4 years, particularly on GI Bill parity. We're going to continue to work very hard on that, and I look forward to our continued partnership on many of these issues. One area for improvement I want to explore is USERRA's limitation that the cumulative length of service that causes a person's absences from a position may not exceed 5 years. So I want to ask each of you, we'll start on your side. Is the 5-year window adequate for employees who stay with one employer for a long period of time? Colonel Patton, we'll start with you.
I'll start off, Ranking Member, by stating that there are exceptions or allowances to the 5-year limit, first off. And those are, and I'm going to paraphrase, but those are for things such as readiness training. Training isn't all done up front, one shot, and then you're trained for life. Certainly our tactics, our procedures, our equipment, our technology evolves over time. Units are remissioned over time. There's developmental education that a military member receives perhaps in their 30s or their 40s that just wouldn't have the same efficacy giving it to an 18-year-old military member. So there are allowances for all sorts of those things. And I would say in a very generalized sense that those allowances are fairly adequate. Having operationalized the reserve component in the 1990s, and then the demands that were then placed on the operationalized reserve components soon after 9/11 have certainly then invoked other exceptions that require a military member to be, if they deploy over and over and over again, they may exceed that limit with a particular employer. And so there are exceptions in the law, and those exceptions are granted to different levels within the executive branch depending on which status in which the member is called to service.
Thank you. I want to make sure to get everybody in, and we only have 5 minutes, so I'll go to Mr. Hadley.
Thank you, sir.
Thank you, sir. Yeah, I would agree with the first witness's statement there. And I don't think that it is an easy one-size-fits-all kind of provision that's in there. There's a lot of unique circumstances that occur throughout the course of a service member's life and employment life as well. So I think that we need to explore that and look for ways that we can capture that and accommodate those needs.
Thank you. Mr. Hollinger.
Well, as the enlisted member, we're going to keep it really, really direct and say, no, it is absolutely not enough time. I served 22 years in both the Army active duty and in the National Guard. I have 11 combat deployments. If this rule would have solely been enforced on me, I would not have had a job. As we stay in longer, our senior leadership becomes extremely important and vital to our success. And because of that fact, we are very loyal on the outside. 5 years is not enough, sir.
Thank you. Mr. Taylor, you get the last word here.
Sure, I'll keep it brief. I haven't studied the issue carefully enough to offer an opinion, but what Mr. Hollinger just said sounded pretty good to me.
Let me ask you, Mr. Hollinger, can you speak to any instance in which you've seen a service member personally impacted by the 5-year window? And I think you just mentioned your own experience.
I only have one example. I'm not going to use his name because I haven't talked to him about it, but it was in northern Indiana at one of the steel mills. And as he came on his 7th deployment, and it was about 2015, he was told not to come back. Now, his union was very strong and just sent him to a new steel mill when he got back, but that did come into effect.
Gotcha. And one last question for you, Mr. Hollinger. You noted in your testimony the U.S. Supreme Court decision Torres versus Texas Department of Public Safety. It held that states may not invoke sovereign immunity to avoid liability under USERRA, but that's not specifically codified in law, is my understanding. What's your position on the decision, and can you speak to the need for legislation on the issue?
Well, I think government accountability, especially when it comes to employment, is the utmost importance. I think the government sets the standard for all the rest of us to follow. So I think our standard the government standard needs to be a lot higher and make sure that they're following the law. So as far as that decision, I truly do believe that an individual that is affected at a state level does need that easy path through. Opening the case in their name in a federal court or in a state court is imperative. It's very, very hard for especially lower enlisted individuals to wait 5, 6, 7 years for a case to work through DOJ or through DOL and try to get resolution. We need to take care of these.
Over time, but thank you all for your testimony, your service, and I'll yield back to the chairman.
Thank you, Ranking Member Levin, and I'll recognize Mr. Siscomani for Arizona for 5 minutes.
Thank you, Mr. Chairman, and thank you again to all the witnesses for coming here with us today to testify. A question for the Colonel. In your testimony, you suggested that another agency might be more appropriate to administer the USERRA. How do you think it would benefit service members to have another agency administer the program? And part of that, what issues would you foresee with moving the program out of the Department of Labor?
Thank you for the question, Mr. Siscomani. To be clear, I did not make that as a recommendation, or certainly didn't intend to in my oral remarks. It's merely an acknowledgement that it's our understanding that there's a discussion going on within staffs of potential legislation that might do so. As far as the challenges to another agency, I would foresee that those could be very similar to the challenges that the current agency has with consistent USERRA enforcement.
So how do you, based on the discussions that are going on, how would you think it would benefit?
Certainly, this will be my own opinion, but as a veteran, having worked through the systems, if you will, of veterans benefits, both with the Department of Labor and the Department of Veterans Affairs, I might suggest that the Department of Veterans Affairs has kind of had that watershed moment culturally already in terms of how it responds to and provides to veterans' needs, particularly their statutory needs, and that Department of Veterans Affairs might be further down the road of being veteran-focused and able to be responsive to those veterans' benefits. But that's purely my personal opinion.
And it'll be noted as that.
Pretty speculative as well, so.
Understood. Thank you for your thoughts on that, Colonel.
Thank you, sir.
I appreciate it. Thank you for your service. Mr. Hollinger, for your membership, how long does it usually take for a claim to be resolved by the Department of Labor in your experience?
I don't have that exact number up. I would say a lot of times by the time it gets to the Department of Labor is what would be the variation on that. I would say it would probably be somewhere around a year.
About a year?
Personal.
And how long would it generally take for a claim to be resolved, do you think, in Veteran Affairs or Department of Justice?
Well, I'm not advocating for it to go anywhere else. I'm advocating for them to be able to bring it in their name into a courtroom of their local jurisdiction or the federal side. I'm not advocating for another department or another bureaucracy at all, sir.
Okay. Now, do you think that most businesses are aware of the protections afforded to service members by USERRA? And what steps could we take to make sure that more businesses are aware?
I believe that the education needs to come a lot through the military service community. So a business that is not aware of how USERRA works, please refer them to me. Number two, I think most businesses are very patriotic and love this country. I think the wear down of a 20-plus year war has fatigued a lot of businesses and kind of hurts the decision-making process every once in a while. I think most of these cases would be settled outside of a courtroom if they were opened in the name of the individual.
Gotcha. Thank you so much, Mr. Chairman. I yield back.
Thank you, Mr. Siscomani, and I recognize Mr. McGarvey from Kentucky for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Hollinger. I appreciate what you just said, too, about the fact that we are 20 years going on this. I mentioned my brother in the previous panel who got commissioned in May of '02. and watching what he's gone through in his career, the number of deployments, how hard that is on families. I want to continue to hit a little bit on the questions I was talking with Mr. Rodriguez about spousal protections. I mean, we know what we're asking our men and women who are willing to put on a uniform to keep this country safe to do. And that is whether it's being activated, whether it's being deployed, whether it's going to a natural disaster, if you're in the Guard, something like that. We expect a lot, we require a lot. And there's honestly not often a ton of notice on when you're leaving or a lot of certainty on the date you actually come back. Dr. Taylor, you told the story about the individual who was given the party and then the same day given a party by the employer, let go on going to active duty. This is tough. This is tough on readiness of our force, and I again want to go back to the spousal part of it. Mr. Hollinger, I know you know just as much as probably anybody about what our members go through when they're activated, called to serve, and you know the difficulty that their spouses go through when that happens. Could you speak a little bit more about why expanding USERRA protections to spouses would improve our readiness and well-being of our National Guard and service members?
Well, I think everybody in this room is aware of how important our spouses are. Mine sits right behind me, right over here in the blue dress. Anyways,
Thank you both for your service.
the spouses are the most critical aspect of what we see every day and what makes the National Guard function. Without them, everything ceases to maneuver. Retention, recruiting, all of this stuff will suffer greatly without the spouses. When a spouse is thrust into that environment where they have to be the sole caregiver to their household, it takes tremendous dedication, patience, intelligence. They are the heartbeat of what happens in the National Guard. They need that protection just like their active duty service members. As I said earlier, I deployed 11 times. That's the easiest thing in the world to do, is deploy. I had great leadership that said, go that way, do great things for America, and I did that. But my spouse who sits at home doesn't have that same leadership to say, hey, go that way, make sure your kids do great things for America. She has to figure that out on her own. And I think that's the important part that we need to focus on, is how important the spouses are every single day.
Amen. Thank you for sharing that. And I'm going to ask you the same question that basically I asked Mr. Rodriguez as well. If you could just tell us what Congress should be doing to improve the enforcement of USERRA, and what are you hearing from your membership in that regard?
To make sure that the enforcement, I think DOL is making great strides going forward. I think if we support them, continue to support them, I think the right individuals are probably in place there. I'm very fortunate when it comes to DOL and very pro what they're doing today. I have an individual, so I'm not sure if he's still back there. I've called him commander 2 different times. I've called him friend, and now I call him, I call him coworker. I think he is the right guy to have there. I think Mr. Rodriguez is the right guy to have there, and I think DOL will do great things.
Thank you. I appreciate it. Mr. Hollinger, thank you for your service, and to your spouse, thank you for your service as well. I yield back.
Thank you very much, Mr. McGarvey. I appreciate it greatly. This panel is excused from the witness table. I want to thank our witnesses for appearing today to discuss this national security issue, because that's what USERRA is. We've got to make sure that our service members are protected while they serve overseas or in the United States in emergency declarations. We also have to make sure that DOL vets continues to do their good work. In the future, I do not hope, but I expect to see the Department of Defense here as witnesses as well. Their absence is duly noted, and it is unacceptable. So USERRA, SCRA, and the TAP programs are important programs that this committee has jurisdiction over, but the Department of Defense administers them. And we need them to show up to do their job. With that, I yield to Ranking Member Levin for any concluding remarks he may have.
I associate myself with the Chairman's comments regarding the Department of Defense. This is something that would consistently frustrate me throughout my 4 years as Chairman. Getting all the relevant folks to attend these hearings is essential for us to do our work on the subcommittee. And we're grateful to those of you who are here and who stayed for our second panel. But I also want to congratulate the Chairman on a fine first hearing of our subcommittee. I'm looking forward to really an excellent couple of years. And with that, I'll yield back.
Well, thank you, Ranking Member Levin. And I want to thank you all for coming here today. Your participation is vital so that we can help do what's right by our veterans. And I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and included extraneous material without objection. So ordered. The hearing is adjourned.